Hey everyone, and welcome back to Exposed, Scandalous Files of the Elite. I am your host, Jim Chapman, and we are going to pick up with this 11th episode in the Murdaugh series. In the last time that I left you, Alex Murdaugh had been arrested along with cousin Eddie Smith for insurance fraud and a slew of other charges related to Alex Murdaugh's supposed suicide attempt via cousin Eddie, of course, shooting him in the head on that roadside highway. So Murdaugh actually gets granted bail and he's released from jail on these charges pending his trial with the stipulation that he surrender his passport, which he did. And that was on September 16th of 2021. Murdaugh then immediately reports to a detox/rehab facility in Orlando, Florida to get control of his addiction to painkillers. And in the meantime, that Satterfield case is heating up. Now, I covered that entire Satterfield case for you in a prior episode of Murdaugh. But in the interest of remaining on the timeline, I need to address exactly what was going on during the time Murdaugh was in Florida at that rehab center. So the lawyers for the estate of Gloria Satterfield, they're investigating everywhere in an effort to prove the settlement funds due to their client were stolen by Murdaugh and his co-conspirators. And think about that. At this point in time, September of 2021, Murdaugh is not only the prime suspect in his wife and son's murder, but he's also facing major insurance charges, fraud specifically related to the roadside shooting, and is being investigated for stealing millions of dollars from the Satterfield family. All of this happening at the exact same time. So while he's in that Florida rehab, the lawyers for the Satterfield family, they start getting their shit together and they file a motion in court regarding not only Alex Murdaugh and his co-conspirators, but also Murdaugh's law firm and its partners known as PMPED. Now that stands for Peters, Murdaugh, Parker, Ellsworth, and Dietrich. And those were the partners in Murdaugh's law firm. In an article by Fit News, which was put out on October 5th of 2021, it really covered it well, and here's how that read. Less than 2 weeks after denying they had any role in the Gloria Satterfield settlement, partners at the Murdaugh family law firm, Peters, Murdaugh, Parker, Ellsworth, and Dietrich, now have a lot of explaining to do after a new court document alleged the Hampton, South Carolina firm participated in the fraudulent scheme to steal millions from the Satterfield sons. Satterfield, who was Murdaugh's family housekeeper for more than 2 decades, died after an alleged trip and fall accident at the Murdaugh home in February of 2018. On September 15th of 2021, SLED opened an investigation into Satterfield's death and a wrongful death settlement after a Hampton County coroner found inconsistencies in her death. Days after SLED opened that investigation, an article was published that revealed how Alex Murdaugh allegedly worked with his 2 friends, Corey Fleming, an attorney, and Chad Westendorf, a banker, in a scheme to take millions of dollars from the Satterfield sons after her $4.3 million secret settlement was approved by Judge Carmen Mullen in 2019. The motion, filed Tuesday by Eric Bland, who is representing Satterfield's 2 sons in a lawsuit against Murdaugh and his 2 co-conspirators, asked to bring Fleming, Westendorf, and Murdaugh into court to testify under oath about what happened to the settlement funds. Bland is also asking a judge to hold Murdaugh and his co-conspirators in contempt of court for blatant and willful violations of court orders. The motion is accompanied by damning documents that show PMPED employees, aside from Murdaugh, were aware of the settlement. The documents display a clear paper trail that indicated Alex Murdaugh committed financial crimes and Fleming, at the very least, violated rules of professional conduct as an attorney. According to court documents, $2.8 million of Satterfield's settlement was supposed to go to her sons, who are the only beneficiaries of her estate. However, Satterfield's two sons hadn't received a single dime from their mother's wrongful death settlement. That is, until Friday, when Fleming and his law firm Moss, Kuhn, and Fleming agreed to a settlement in a malpractice case. On Tuesday, Bland received a check from Westerndorf for the $30,000 he accepted in the case, which means Alex Murdaugh is the only party remaining who has not agreed to pay back money from the settlement. Fleming, the attorney who originally represented Satterfield's sons and Murdaugh's lifelong friend, decided to come clean and pay back the money they took in legal fees, only after multiple media reports and a lawsuit pressured them to do so. In fact, one of Fleming's law firm partners told the Island Packet newspaper on September 24th that he was planning on filing a countersuit against Satterfield's estate, claiming the accusations made in the lawsuit were false. Just 1 week after making that claim, Fleming's law firm agreed to settle the lawsuit. On September 10th, Bland sent Fleming a notice asking him to produce all of the materials related to the Satterfield settlement. Finally, after the Satterfield story made headlines in nearly every major news outlet in the United States, Fleming turned over the documents to Bland. Those documents, which appeared to provide evidence against several powerful players, are included in the most recent motion. Documents filed Tuesday show emails and letters from Alex Murdaugh and his paralegals acting as representatives of the estate of Gloria Satterfield in the wrongful death settlement. That would be Alex Murdaugh, the only defendant in the settlement, claiming to represent Satterfield's sons, who are the plaintiff. Murdaugh's law firm sent letters of representation of the estate to third parties, prepared probate documents for the estate and personal representative of the estate, notarized probate documents, etc. Recently, Bland filed a motion asking that Mullen detain Alex Murdaugh for the role in the Satterfield settlement based on South Carolina law that states a person can be arrested in a civil case without criminal charges in some circumstances. And then it gets into how that scheme works, y'all, and it's really the most interesting part of this. It says, at Gloria's funeral, Alex allegedly started railroading her sons and convinced them to hire his friend Corey Fleming to get money for their mother's death. However, Satterfield's sons did not know that Fleming was Murdaugh's former college roommate, best friend, and Buster Murdaugh's godfather. Alex Murdaugh also convinced Gloria's sons they needed to have a banker, and that was Westendorf, work as their personal representative of Gloria's estate. Bland later learned that Alex Murdaugh's insurance company actually settled more than $4.3 million, with $2.8 million that was supposed to go to his clients. Murdaugh and Fleming apparently claimed they were doing a structured settlement for the Satterfield sons, although this was never disclosed in court. Essentially, this would work like a trust. Instead of getting a lump sum, the plaintiff would receive more money over time with tax breaks. Murdaugh claimed that he set up an annuity account for Satterfield's son through a company called Forge Consulting, LLC. The only problem is Corey never got any documents from Forge, and he's taking the direction from the defendant, Murdaugh, who tells him after you take the fees, write a check to Forge and send it to a P.O. box in Hampton, South Carolina. Alex Murdaugh allegedly told Fleming to make the checks out to Forge, not Forge Consulting, LLC, after he set up an account with that name. Alex Murdaugh opened the bank account at Bank of America under the name Forge, got the check cashed, and walked away with the money, Bland said. Fleming is claiming that the only money he received from the settlement was from legal fees. He told Bland he was victimized and fooled by Alex Murdaugh. It appears that after the Murdaugh family was thrust into the limelight following the boat crash, Alex Murdaugh was able to convince the court to drop his name from the caption of the document where it would typically state Gloria Satterfield versus Alex Murdaugh. According to Bland, this order is concerning for a number of reasons. Alex's name is not listed as the defendant at the top as it should be. Alex did not ask the court for permission to remove his name. There's no docket number listed on the document. The document was not entered into the court, and he lists other reasons for that. So, of course, at this point, the law firm has to respond, right? They have now been accused of knowing full well that Alex Murdaugh was ripping off the Satterfield family of millions of dollars. And respond they do. So I have that lawsuit, and it really details the law firm's side of this whole mess. So let's get into that. And this response was dated October 6th of 2021. And it's very interesting. It says, in early September of 2021, PMPED discovered that during the course of his employment at the law firm, Alex Murdaugh was converting client and law firm money for his own personal use. His actions were unknown to the law firm until this discovery, and these actions were unauthorized by the law firm in violation of the law firm policy. In early September of 2021, the law firm discovered Alex Murdaugh had a bank account with Bank of America in the name of Alex Murdaugh DBA Forge, a fictitious entity that provides no services and makes no products for sale. It was further learned that Alex Murdaugh used this account to convert money owed to the law firm and its clients to his own personal use. The law firm has determined that Alex Murdaugh was able to covertly steal these funds by disguising disbursements from settlements as payments to an annuity company, trust account, or structured settlement for clients, or as structured attorney's fees that he had earned when in fact they were deposited into a fictitious Bank of America account. At the present time, the law firm has identified certain files in which Alex Murdaugh utilizes this scheme. Alex Murdaugh knew that his actions would evade detection based on his experience with the law firm and its long-standing business relations with Forge Consulting. For many years, Forge Consulting has provided valuable services to some law firm clients. Those services include brokering structured settlements and annuities, as well as the creation of specialized trusts to protect client assets. Forge is an outstanding company that has earned respected reputation throughout the country. In addition, Alex Murdaugh was aware that FCL has provided law firm attorneys with financial advice that includes structuring attorney fees. Alex Murdaugh was able to use this business relationship in conjunction with fictitious and misleading business name to draft checks from the law firm client trust account made payable to Forge or Forge Consulting LLC, and deposit those checks into his personal Bank of America account. The law firm was unaware of this scheme until September 2nd of 2021. Prior to that date, the law firm had inquired on the status of a fee owed to the law firm from a file that Alex Murdaugh worked along with another law firm, and they're referencing the Satterfield case. The law firm received a check for his expenses incurred during the course of that litigation, but not a check of fees owed to the law firm. Questions regarding the check for the fees owed to the law firm failed to produce a satisfactory explanation. And here's where it gets really interesting. On October 2nd of 2021, a check was found in his desk from the other law firm. According to the note on the check, it was a partial payment of the fees at issue. However, the check was made payable to Alex Murdaugh and not the law firm. It had been deposited into a personal account for Alex Murdaugh and not the law firm. The discovery prompted a review of prior settlements of cases Alex Murdaugh resolved. This review showed numerous checks made payable to Forge or Forge Consulting LLC, but the files did not contain the normal documentation that is required to perform the services offered by FCL. The law firm consulted with FCL on September 2nd of 2021 concerning the checks discovered during its review of Alex Murdaugh's files. On September 2nd of 2021, FCL confirmed that it had not provided any services for the clients identified by the law firm. Moreover, FCL stated that it had never assisted the defendant with structuring any attorney fees. FCL was not assisting the defendant in his scheme and had no knowledge of the improper use of its name or its conduct. So before I go any further, and to avoid any confusion, FCL is actually a legit company. And it's actually called Forge Consulting, but it's not Forge Consulting LLC. So when Alex set up Forge, it was intentional. He wanted the people at his law firm to assume that was going to Forge Consulting LLC. So just to avoid any confusion there. So it gets better. On the morning of September 3rd, 2021, Alex Murdaugh was confronted with this information that the law firm discovered through its review and discussions with FCL. Alex Murdaugh admitted to converting monies owed to the law firm and its clients to his own personal use. The law firm requested the immediate resignation of Alex Murdaugh on September 3rd of 2021, which was received that afternoon. And that was just, remember, a day before the roadside shooting. On September 4th of 2021, the law firm notified the Hampton County Sheriff's Office and SLED of the suspected criminal activity of the defendant. Upon information and belief, that investigation is ongoing. On September 6th of 2021, the law firm notified the South Carolina Supreme Court Office of Disciplinary Counsel of the suspected ethical violations of Murdaugh. Upon information and belief, that investigation is ongoing. The law firm immediately retained a forensic accounting firm to begin a thorough review of all financial activities of Alex Murdaugh while employed at the law firm, and that review is ongoing. The law firm has reimbursed all client trust accounts who have suffered a known loss as a result of Alex Murdaugh's action while he was an employee of the law firm and working on behalf of clients of the law firm. It's anticipated the additional information may become known that could lead to more losses to the law firm as it protects its client's interest. Upon information and belief, Alex Murdaugh used firm assets in an unauthorized manner and without the consent and knowledge of his or other shareholders to further scheme and defraud. So there you have it. That was their answer to it. And it's very important. The reason I took so much time to read that to you is because this piece of litigation right here is going to be a big feature in his trial upcoming. And primarily because it proves who the fuck this guy really is. That's low. When we get to the part where you discover who he was stealing from, the type of people he was stealing from, you're not going to believe it. I mean, this was not just the Satterfields. Let's just say that. So all this comes out in obviously the paper, local news, national news, and the media was all over it. And one question that was being asked more than any other was, how in the hell has Alex Murdaugh not been arrested for this? Well, a viral article that really asked that very question came out. It was from Fit News, and it read like this. It said, in the last 3 weeks, South Carolina attorneys Eric Bland and Ronald Richter have uncovered a shocking paper trail that shows how Alex Murdaugh stole $3.6 million from his housekeeper's grieving family. On Tuesday, Bland published a bombshell motion that appears to show evidence stacked up against Alex Murdaugh and his two friends, Corey Fleming and Chad Westerndorf. Even his family's law firm was mentioned for their alleged roles in the $4.3 million secret settlement for Gloria Satterfield. The paper trail of evidence showed Alex Murdaugh led the pack in a scheme to steal millions of dollars in Satterfield's 2019 wrongful death settlement. Satterfield died after a trip and fall accident at Alex Murdaugh's home. Bland has the checks Fleming sent to an account Murdaugh set up called Forge, and he has proof that that money was deposited into Murdaugh's bank account. We're talking $3.6 million in 3 checks that were sent over the mail to a P.O. box and deposited into a bank, Bland said, emphasizing how serious a crime this is. Ordinary people who write a bad check for $100 are sometimes arrested quickly, he said. While Fleming, his law firm, and Westerndorf have agreed to pay back all of the money they took in the $4.3 million settlement from the Satterfield sons, Murdaugh hasn't offered to pay a dime, Bland said. Fleming is the only co-conspirator who has apologized to Satterfield's two sons. In a statement issued Wednesday, Fleming claimed he was fooled by his friend Murdaugh, but acknowledged that material mistakes were made at crucial times. He claims until early September of 2021, he sincerely believed the settlement funds had been properly dispersed. The only thing Corey Fleming did right is that he recovered $4.3 million, Bland said. But every single thing besides that he did was wrong. He violated the rules of professional conduct, violated the standards of care, and violated common sense. Bland, who is representing Satterfield's two sons in a civil lawsuit against Murdaugh and his co-conspirators, said that he turned over all this information to SLED, and he believed the documents provided enough probable cause to arrest Murdaugh for multiple financial crimes related to the settlement, including conspiracy to commit fraud, mail fraud, and wire fraud. SLED officials confirmed they met with Bland, who provided them with documentation. Bland said he is concerned about the status of the SLED investigation. SLED is the same agency investigating the June 7th double homicide of Alex Murdaugh's wife, Maggie Murdaugh, and son, Paul Murdaugh. Since the double homicide, SLED has opened 4 criminal investigations related to the Murdaugh family. How is Alex Murdaugh still walking the streets and not arrested and charged with theft of approximately $3.6 million, Bland said. My partner and I solved this apparent and significant crime 2 weeks ago and provided the documents to the court and to the public in our filing. To be clear, Alex Murdaugh is allegedly in rehab right now following his September 17th bond hearing for his alleged role in a bizarre assisted suicide for hire insurance fraud scheme. His attorneys, who have lied to the public before, claim he is in rehab for opioid addiction. At his bond hearing, a Hampton County judge ruled that Alex was not a danger to society and not a flight risk. The longer Alex Murdaugh gets to sit in a treatment facility and try to get himself better, he could possibly still commit more crimes by getting rid of some of the money or figuring out a way that it can't be traced and found, Bland said. Bland said his clients, Satterfield's two sons, the only beneficiaries of the estate, have not yet been interviewed by SLED, which is concerning to him for a number of reasons. SLED did not comment on whether or not they have interviewed Satterfield's two sons. Alex needs to eat from the same trough of justice that every other citizen in our state eats from, Bland said. It's obvious exactly what happened through the documents that are now in public domain that he stole $3.6 million from my clients. More importantly, his own law firm in a public pleading has said he did it to other clients using the exact same method. Just a day after Bland filed his bombshell deposition that revealed the law firm's involvement in the Satterfield scheme, the law firm pulled a fast one and filed a lawsuit that appeared to be damage control, distancing its partners from Alex Murdaugh. If Alex Murdaugh was arrested for this, it would send a strong message to all those he may be working with, Bland said. It would show that our state is serious and maybe we're going to be holding these people accountable, but it's starting to look like a joke. SLED has only arrested 2 people in the 5 criminal cases that are currently being investigated in relation to the Murdaugh family. Alex Murdaugh and drug dealer Curtis Smith were arrested in September in the alleged suicide for hire scheme. However, SLED's investigation is far from over. Bland, who has been a malpractice lawyer for more than 35 years, said he has never come across a case as rotten as this one. I've sued over 175 lawyers and law firms. You can add them all up and it doesn't equal what's going on here because this is top to bottom. This is judges, lawyers, money, everything. And that was the question of the day, y'all, as this whole thing was unfolding, was how in the hell has he not been arrested for these other crimes? Really, at this point, the only thing he's been sitting in jail for is the assisted suicide insurance scheme. Now, maybe it was a break in the case, or maybe it was the media pressure. But guess what? On October 14th of 2021, Alex Murdaugh indeed gets arrested yet again, this time for stealing millions from the Satterfields. And here is how that article read. Alex Murdaugh was arrested in Orlando, Florida on Thursday on charges related to the Gloria Satterfield case. According to the South Carolina Law Enforcement Division, SLED, Murdaugh was charged with 2 felony counts of obtaining property by false pretenses, and he faces up to 10 years in prison on each charge. These charges stem from a SLED investigation into misappropriated settlement funds used in the death of Gloria Satterfield. SLED officials said in a statement that agents arrested Murdaugh after he was released from a Florida rehab facility for his alleged drug addiction. According to sources, Murdaugh detoxed at the facility and then was transferred to another facility in Orlando, Florida, where he was scheduled to be released today. Murdaugh was taken to the Orange County Corrections Thursday morning. He will be held in Florida until he is extradited to South Carolina, where he will have his bond hearing. Murdaugh's extradition hearing is tentatively scheduled for 1 p.m. Friday in Orange County, Florida. If extradition is granted, which it was, he'll be transferred to South Carolina likely on Saturday. According to sources, Murdaugh's bond hearing could be held in either Beaufort County or Richland County. Considering the fact that Judge Clifton Newman has been appointed in that case, the bond hearing will likely be held next week. That means Murdaugh will likely have to spend the weekend in jail. Oh, poor Murdaugh. And then it goes into what I've already told you about how they came up with all this evidence. So I'm going to speed up just a bit because all of these episodes that we have put out so far were to prepare you for the crescendo of this whole thing. So on October 14th of 2021, what I just read you, Murdaugh was arrested at that Florida detox center, and he was charged with swindling millions of dollars from the son of Gloria Satterfield. And he was eventually jailed in Richland County, South Carolina. He goes for bond, and he was twice denied bond. Then on December 13th of 2021, during a hearing at which a judge set his bond at $7 million, Mr. Murdaugh's lawyer said that his client had agreed to pay $4.3 million to Miss Satterfield's family. He remained in jail. Then, on June 28th of 2022, Murdaugh and Smith are indicted by the state's grand jury. And I have that indictment, and this indictment is a 2-person indictment. So it's Curtis Edward Smith and Richard Alexander Murdaugh. And it says, over the course of many years, Murdaugh provided to Smith hundreds of checks with the common understanding that Smith would convert the checks into cash in whole or part and use the proceeds for Murdaugh's benefit with the intent of carrying on and concealing myriad unlawful acts. Between October 7th, 2013 and February 28th of 2021, Murdaugh wrote at least, get this y'all, 437 checks intended for Smith with a sum value of $2,413,754.79, nearly all of which were structured in amounts less than $10,000 in order to prevent banks from reporting the large currency transactions as required by law. So any check over $10,000 has to be logged and reported to the federal government in any way, case, or form. And of course, being a lawyer, Murdaugh knew that, so he'd write a check, say, for $9,500. And the federal government would not be alerted to that check being cashed. And it goes on, Murdaugh drew the checks on accounts under his control at multiple banks and made the checks payable to various versions of Smith's name, as well as to close associates of Smith. In some instances, Smith forged the endorsement of his close associates without their knowledge or consent, then endorsed the check himself. In any case, Smith converted the checks into cash or deposits. Murdaugh and Smith structured many of these transactions and used them to facilitate the acquisition and distribution of illegally obtained narcotics, all in violation of South Carolina law. So that was count 1. Let's go to count 2, which is money laundering. That Curtis Edward Smith in Colleton County from on or about May 25th, 2018 through May 24th of 2019 did conduct financial transactions with property that he knew was the proceeds of or derived directly or indirectly of unlawful activity. During that period, Richard Alex Murdaugh provided to Smith numerous checks with the common understanding Smith would cash the checks and use the proceeds for Murdaugh's benefit with the intent of carrying on and concealing myriad unlawful acts. Murdaugh wrote each check in an amount less than $10,000. We covered that. These transactions exceeded $100,000 in a 12-month period, and they're talking about specific checks that they tracked in that time frame. Then another count of money laundering at $100,000 or more. So they actually found some checks, y'all, that were written for $100,000 plus dollars, and there were several counts of that as well. And most of these lawsuits were for the money laundering aspect. But they had something interesting, and that was the forgery aspect of what they were doing. That was a 6th count. And it said Richard Alexander Murdaugh provided to Smith numerous checks made to Smith's daughter without her knowledge as part of a scheme to launder money. Smith forged his daughter's endorsement signature to the checks and thereafter submitted them to Enterprise Bank of South Carolina, thereby defrauding the bank and other financial institutions party to the negotiation of the instruments. The value of the checks exceeded $10,000 collectively. So what a piece of shit. He's even involving his daughter in his illegal shit, right? But he didn't stop at his daughter. In count 7, it says Richard Alexander Murdaugh provided to Smith numerous checks made out to Smith's girlfriend as a part of the scheme to launder money. Smith's girlfriend ultimately resisted the scheme, so Smith forged his girlfriend's signature on the checks and then endorsed those checks himself. There were several counts after that were numerous drug charges. They even had a simple possession of marijuana count as one of these charges. Apparently, when they originally arrested Curtis Edward Smith, they found him with some weed on him. So they threw that on there too. So you got like 12 counts here that you spend the rest of your life in prison, right? And that 12th count is simple possession of marijuana. So they were tacking everything on that they could in that situation. So if you think it's bad so far, the worst finally happens. When on July 14th of 2022, Alex Murdaugh is indicted on 2 counts of murder for the murder of Maggie Murdaugh and the murder of Paul Murdaugh, what I've been working you towards this whole series. So what happens at this point? Well, now that the grand jury has indicted him, which incidentally, for those of you that aren't familiar with how a grand jury works, they work in secret. It's essentially a trial, but the defense at that time, they don't have an opportunity to defend whoever it is on trial. There's a jury, they meet in secret, and basically the prosecution presents their evidence, and that jury determines, is enough evidence present to warrant a trial? Is there enough evidence to find someone guilty? If they think there is, that is what's known as a true bill indictment. That was what was issued here, which means, hey, we're going to go forward with a trial. Now, at that point, you get arrested, which Alex Murdaugh did as soon as he left that facility in Florida, and he got charged for those murders. At that point, you have an arraignment. And I'm going to play you the clip of the full arraignment. It's about 19, 20 minutes in length. Very important. As you know, we don't skip things. I don't play just little short clips. And the reason I don't do that is it's so important that you grasp every aspect. I'm not going to cut that up. There's so much pertinent information that a lot of podcasts leave out. We don't leave that out here. So I'm going to play the full clip. This is the arraignment. Again, not too long, about 19 minutes in length. And you're going to hear some voices. One of them is the judge, very well respected judge by the name of Clifton Newman. And I'm going to cover a little bit about him on next week's episode. You'll also hear the voice of the prosecutor, amazing prosecutor you're going to find out as we get into this. His name is Creighton Waters. Finally, the voice for the defense that you're going to hear is Richard Dick Harpootlian. Senator Richard Dick Harpootlian, which I told you a little bit about in the past episodes. So those are the voices you're going to hear. Alex Murdaugh is present for this arraignment. And incidentally, if you are on the Patreon, I'll upload that full clip of the arraignment. But here it is, the arraignment of Alex Murdaugh for the murder of Margaret Murdaugh and Paul Murdaugh.
Thank you. Be seated. Good morning.
Good morning, Your Honor.
Yes, sir, Mr. Waters.
Your Honor, we are here today on the case of the state versus Richard Ellick Murdaugh. He has been indicted by the Colleton County Grand Jury on July 14th, 2022 for 4 charges. Those charges are 2022 GS 15-592. That charge is for the murder of Maggie Murdaugh. 2022 GS 15-593. That is for the murder of Paul Murdaugh. 2022 GS 15-594. That is possession of a firearm during commission of a violent crime for the murder of Maggie Murdaugh with a rifle. And 2022 GS 15-595. That is possession of a firearm during commission of a violent crime for the murder of Paul Murdaugh with a shotgun. Your Honor, I am right now serving a copy of the indictment upon defense counsel. Obviously, Mr. Murdaugh is present in court and represented by his counsel, Dick Harpootlian and Jim Griffin. Your Honor, it's my understanding at this time that the defense would request a formal arraignment. So we need to conduct that procedure at this time, Your Honor.
All right. Mr. Harpootlian, is that right?
Yes, Your Honor. Yes, that's fine. Your Honor, it's my understanding that they do want the formal arraignment but are waiving reading of the indictments.
That's correct, Your Honor.
All right.
Richard Ellick Murdaugh, if that is your name, please raise your right hand. Do you waive reading of the indictments?
Yes, sir.
What say you, Richard Ellick Murdaugh? Are you guilty or not guilty of the felonies wherein you stand indicted?
Not guilty.
How shall you be tried?
By God and my country.
Thank you.
You've been so arraigned.
Thank you, Your Honor. Very quickly, as we move forward, the first thing I need to point out is that Attorney General Alan Wilson, of course, has been very involved from the beginning of this case, providing leadership on this case. He's currently traveling today and understands, though, the need to get this done, and so has permitted me and Mr. Zelenka to proceed with this matter. Also, very quickly, want to thank my SLED agents. We have Special Agent Dave Owen present, who's been one of the lead case agents on this. And I want to commend them on the long and arduous investigation over 13 months in which every possibility was considered before the evidence, as we explored every possibility, all came back to one person, and that is Ellick Murdaugh. I'm happy to detail some of our defenses advised me that they are willing to consent to a no bond. So I will leave that to Your Honor's discretion, whether you wish me to go into some of the facts or if that take care of that matter. Once we get through bond, I do know that the defense and the state wish to discuss a few motions at this time as well, Your Honor.
Please report, Your Honor.
Yes, sir, Mr. Harpootlian.
Your Honor, we're consenting to no bond. He's, as you know, already has a $7 million bond he can't make. The further discussion of the alleged facts in this case in an open courtroom, we think continues to run the risk of polluting the jury pool, which in a moment I think we can talk about a speedy trial in this matter, which will occur in this courtroom. So we don't believe there's any reason to go into factual background. He's agreeing to no bond, and so we can move into the more procedural motions that we have. And I think we actually worked out an agreement on all the motions. So if we could do that, Your Honor.
Yes, sir.
Your Honor, beg your pardon, Doug.
And Your Honor, very quickly, I'm going to just add that we have, of course, consulted with the victims in this matter. Our victim advocate is present, and some of the victims, of my understanding, are joining through the remote procedure. I just wanted to make sure that was on the record. Well, Your Honor, there's a few motions I know that Mr. Harpootlian and I have discussed. One of the first motions that has been discussed is a gag order. The state has no objection to a gag order. Mr. Harpootlian discussed it with me, and we do agree that that would be appropriate in this matter, given the amount of media attention. This case, as I've been saying all along at various bond hearings along the way, it needs to be tried in the courtroom, and so the state has no objection to that.
Your Honor, in addition to that, I believe we have an agreement that all discovery material furnished to us will be, even though this is not a statewide grand jury case, will be subject to a confidentiality order, the same confidentiality order that they use in statewide grand jury cases. Am I correct about that?
Well, yes, Your Honor, and another aspect, while that would be appropriate, is much of the information that's been gathered in the statewide grand jury case, all of the 81 allegations of white-collar fraud and other crimes, drugs and the like that's been gathered against Mr. Murdaugh over the course of that long investigation. A lot of that provides the background and the motive for what happened on June 7th, 2021. So that evidence blends together, and it would be appropriate for there to be a global protective order protecting everything related to this case.
Secondly, we propose that all motions in this matter, either filed by the state or by us, be sealed and subject to a motion by either party to unseal it. But that rather than, again, I mean, we're put in a position of filing a motion on discovery to discuss what we've been given and what we haven't been given. And again, this is going to force us to disclose matters to the general public that we don't really want to discuss in public, because we're trying to get a fair trial for a client, not try it in the media, but try it in this courtroom. And I believe Mr. Waters agrees with that.
Your Honor, as long as there's obviously the opportunity upon appropriate showing for motions to be made public and for hearings to be public, then I think that that is appropriate. I think we're not talking about hearings, we're talking about motions.
Correct. And hearings, to the extent that if there's something that needs, we could obviously discuss things in writing, submit them to Your Honor prior to the hearing, and not have those matters necessarily put on the record. But that's something down the line. So, Your Honor, we have an agreement as to confidentiality. We have an agreement as to filing matters under seal. And I think that takes care of that issue. Is that correct?
And obviously, it's the judge's decision, but I believe we are in general agreement on those matters.
Your Honor, could I
Yes, sir.
move on to the next matter?
Well, let's address the matters thus far. Regarding a gag order, what's your understanding as to the parameters of a gag order, which is I typically disfavor? What's your understanding as to the parameters of a gag order?
Well, I think, in Your Honor, it would need to be somewhat limited. I think that obviously there needs to be the ability to advise the public of upcoming hearings. Obviously, we've talked about the ability to advise or to move to unseal motions. But I do think that extrajudicial comments to the press would be the limits of what I see. But that obviously any sort of, aside from notice and that sort of thing, but any sort of hearings that take place in court obviously are fair game.
And Your Honor, we would agree. We're talking about extrajudicial statements, and I'm not here, and I want to make it clear, there's no indication whatsoever that Mr. Waters has in any way made any extrajudicial statements prior to today. But anyone that reads this constant churning out there, it would appear somebody is. It's not him. As far as I know, none of his agents. But we want, if that's violated, we'd like to be able to come before the court and have the court inquire how this material fact got out to see if sanctions are necessary. So to be a gag order to any extrajudicial statement.
So I have the parties prepare a proposed order that you all have you consented to. Proposed order for me to review regarding the gag order.
I will say this, Your Honor. Obviously, this case, and we all know, we can see what's all around us right now. This case has generated a lot of media attention. And again, the state wants very much this case to be tried fairly and appropriately in a court of law. I will say this, just because information does make it into the media does not mean that it necessarily came from law enforcement or prosecutorial sources. But I think that the state is in general agreement that we want to limit that so that, again, things are handled in front of Your Honor in court.
So we'll prepare a proposed order and try to get to some. I'm sure we get agreement on that, and then submit it to Your Honor, hopefully by late this week, early next week.
All right, next regarding sealing of motions.
Not all motions, but any motion which we believe we're discussing evidentiary materials. I mean, typically in a case like this, there'll be some concern about whether or not discovery obligations have been met. And we'd like to be able to not have to detail that in a motion that then is subject to being filed in the clerk of court's office and used by the media to talk about what the facts may or may not be.
I think Your Honor, if I could, the appropriate way to handle that is that if Mr. Harpootlian or the state files a motion and believes that it should be sealed, that they could file an accompanying motion to seal. And then that would just sort of preemptively seal it until the court could address that order at that time.
Fine.
And
That's the manner in which it's typically done, a motion and a motion to seal along with the motion.
I don't think we need global order with that.
We
That
want
can
an
be done,
advance copy before they
warrant.
file it. I mean, they may.
Your Honor, maybe the easiest way to deal with this is if the state, and we'll do the same thing, if the state would agree to give us an advance copy of something we're getting ready to file, to give us the ability to make that motion. And we'll do the same with you. We won't file anything without running it, giving you 48 hours at least, 48 business hours before we file.
That's fair.
You just want it clearly understood that it's a public matter with a public trial, and certainly the matters that need to be sealed can be sealed to preserve the rights of all parties to a fair and impartial trial. And the court understands that, but at the same time, I want it clear that we will not have any private motion hearings. Public matters will be public.
Yes, sir, Your Honor.
Okay.
So we'll get your proposed order on that. Can I move on to the next one?
Yes, sir.
And that is, we filed a motion for speedy trial. We note that there are two terms here, one in October and one in November. And we'd like to go ahead and get this matter before a Colleton County jury as quickly as possible. Mr. Murdaugh does this for a number of reasons. One, as you've heard, he believes he's innocent, he avers he's innocent. And two, he believes that the killer or killers are still at large, and this would allow SLED to put this behind him and go look for the real killers.
Your Honor, the state, as I've already stated, is willing and actually completely agreeable to moving this matter forward expeditiously. I'm hesitant to set a specific term already because there is a very extensive discovery and probably a number of matters that will be needed to address. That could work out. I just think it's a little premature to say definitely that's the term we should schedule it. However, the state is absolutely in favor. The evidence in this case is substantial, and it all points back to Murdaugh. There's forensic evidence as well as all other evidence of his guilt of these murders, and so the state is ready and willing to move this matter forward as expeditiously as could be reasonably done.
And Your Honor, we understand that it's Mr. Waters' belief that there's substantial evidence, both forensic and otherwise. Our response to that is he's wrong, and that's why a jury will sit in that jury box. Is it that jury box? That jury box. One of those, that's the grand jury box? No. Old-timey courthouse, I forget which side we go with. That jury box right there. Hopefully within 90 to 120 days and decide whether that is substantial evidence. Right now, there's October term with Judge Mullen, who she recused herself, and November term with Goldsmith, Brooks Goldsmith from Lancaster County. Those are already set. I don't know that we need to get into that today, but we are going to be pressing for a trial as quickly as possible. In that vein, last week we served a discovery motion on the state. They have 30 days under the rules to respond. This matter's been under investigation for a year and a half. It may be extensive, but it ought to be easily accessible, and we ought to be able to get that in 2.5 weeks and begin the process of coming through it ourselves.
We've already provided them substantial discovery in the other matters, and we will certainly comply with our obligations. Your Honor, I think that once we start that process, and I know, and I agree, that we need to move this matter forward expeditiously. What I don't want to have happen is for the defense to be screaming speedy trial on one hand and screaming about discovery on the other hand. This is a very aggressive timeline, which we're in favor of, but I think we need to see how things develop and find the most reasonable, expedited term we can. And I think we need to start this process for a few weeks and then make an assessment at that time of what is a reasonable term. That might be January. Obviously, Mr. Senator Harpootlian has his legislative obligations at that time.
Which I will waive.
It seems like probably given the realistic expectations in this matter, that January would be a very aggressive and reasonable timeline.
And we may disagree on that, but Your Honor, I would point out, they spent over a year investigating this. They took it to a grand jury. They should have presented them with all the evidence that would have convinced that grand jury beyond a reasonable doubt. And so it's there, it's accessible, you ought to be able, I mean, most of it's electronic, I suspect. They could hit a button and spit it out. We're not going to argue about discovery because I assume they're going to give us everything that would be scientific, everything under Rule 5, everything under Brady, and we're not going to have to fight about it. So we made a motion for speedy trial. I don't know that we need to, until Your Honor decides how to address that, there's no reason for us to draft an order on that. Is that correct?
As far as speedy trial?
Yeah.
I mean, again, I think we need to start the process, Your Honor, and then maybe reassess this matter in a few weeks.
Well, the defendant has a constitutional right to a speedy trial. That being said, however, I am totally unaware of the status of the docket here in Colleton County. I do not know if the solicitor's office for this circuit already has day certain trials scheduled or what other matters that currently exist that might be scheduled already or anticipated by, or whether a special term of court might become necessary to try this case.
And Your Honor, we talk to people, but apparently there's no motion for speedy trial on any case pending in Colleton County right now. So we're the only ones to ask for one, if that makes a difference. And again, we understand it's totally within your discretion, not mine, not his. So we just want you to consider that. And again, I agree with Mr. Waters, it's not something to rule on together. So take the course of whatever.
Yes.
Thank you, Your Honor. That resolves everything the defense has for today. Mr. Waters took that additional.
Nothing further from the state, Your Honor.
Unbelievable.
Special Agent Owen, is there anything you would like to state pertaining to the matters here?
No, sir, not at this time.
Any victim input? Anyone wishes to address anything from the victim's perspective today?
We met with them yesterday. I've not been advised of any specific input.
Anything further then?
No, Your Honor, not for the defendant.
None from the state, Your Honor.
All right. The bond will therefore be denied, and matters discussed this morning will be addressed in written orders where necessary.
Thank you, Your Honor.
All right, thank you all.
And next week, everything I just told you in some 11 episodes now will start to make sense. You will start to see why I took so much time to explain everything to you before I jumped right into a trial. So get ready for that. I want to thank everyone who has shared this show. We grow every single week, and it's because of all of you. I can't tell you how much I appreciate that. It means the absolute world to me. Everybody that's taken time to rate the show, thank you so much. I have to have those ratings in order for that show to grow. And all of you are the best fans in the world for taking time out to rate the show. I really mean that. And the awesome things that y'all say keep me going, keep me fired up, keep me wanting to do this every single week. If you haven't had a chance to review the show, or you're new to the show and you like what you hear, please do so. We have a Patreon. The Patreon helps support this show. It's very expensive. Y'all see the amount of time that I spend researching these cases. In many situations, I have to buy these actual lawsuits online, and they charge. They're like 20 cents a sheet. That's what that type of money goes towards. So you really help with all that. I appreciate it. If you're interested, look, you get a ton of benefits on that thing. We do quarterly gifts. You get commercial-free early releases. You get bonus episodes, all kinds of stuff, and I keep it as active as humanly possible. So go check out the Patreon if you haven't had a chance. Get ready, because next week it is about to be off the chain. Off the chain. You're going to love it. And until next time, for Exposed, Scandalous Files of the Elite, I'm your host, Jim Chapman. Much love.